жерлерді анықтаймын десең де сұрауға болады. Себебі біздің арамызда аудармашы отыр, тілмаш. Тұрыңызшы. А сіз мына жаққа жақынырақ отырмайсыз ба? Я орындықты алып. Рахмет. Good morning, dear colleagues and guests. Today's meeting of the Dissertation Council established for awarding the degree of Doctor of Philosophy, PhD, in the educational programs 6D 021300, 8D 02303 Linguistics, 6D 02100, 8D 02306 Foreign Philology, 8D 01705 Foreign Language, 2 foreign languages, 6D 0207000, 8D 02302 Translation Studies at Al-Farabi Kazakh National University. Dear members of the Dissertation Council, dear participants, let me announce the members of the Dissertation Council present at this meeting. The Dissertation Council consists of 9 members. All 9 members are present at the meeting. Gulmira Madieva, Chair, Doctor of Philological Science, Professor. Albina Dosanova, Deputy Chair, PhD, Associate Professor. Kamar Aldasheva, Academic Secretary, PhD, Associate Professor. Anar Fazıljan, Candidate of Philological Sciences, Associate Professor, Director of the Ahmet Baytursunoğlu Institute of Linguistics. Holders of qualifications in the educational program 8D 02306 Foreign Philology, Western Languages are present. Today, temporary members of the Dissertation Council are attending the defense of Rahia Toksanbaeva Kuankhanovna, who has submitted her dissertation for the degree of Doctor of Philosophy, PhD, in the specialty 8D 02306 Foreign Philology, Western Languages, on the topic Linguosemantic and Cognitive Characteristics of Legal Discourse on the Materials of the English Language. The temporary members of the Dissertation Council are Metin Ekishi, PhD, Professor, Ege University, Izmir, Turkey. Volkova Yana, Doctor of Philology, Professor, People's Friendship University of Russia, Moscow, Russia. Junusova Жаңылдық, Doctor of Philology, Professor, Гумилев Eurasian National University, Astana, Kazakhstan. I declare the meeting of the Dissertation Council open. According to the attendance sheet, all members of the Dissertation Council are present at today's meeting. There is a sufficient quorum to open the meeting. Are there any objections? No. On today's agenda is the public defense of the dissertation submitted by Rahia Toksanbaeva Kuankhanovna for the degree of Doctor of Philosophy, PhD, in the specialty 8D 02306 Foreign Philology, Western Languages, on the topic Linguosemantics, Semantic and Cognitive Characteristics of Legal Discourse on the Materials of the English Language. The dissertation was completed at the Department of Foreign Philology and Translation Studies of Al-Farabi Kazakh National University. Domestic Scientific Advisor Kuralay Kinjikhanova, PhD, Senior Lecturer, Al-Farabi Kazakh National University, Almaty, Kazakhstan. Foreign Scientific Advisor Anastasia Zabrodskaya, PhD, Professor, Tallinn, Estonia. Official reviews: Isakova Asılımay, Candidate of Philological Sciences, Associate Professor, Caspian State University of Technology and Engineering, named after Yesenova. Kakimova Mayra Iringayipovna, Candidate of Philological Sciences, Associate Professor, Manash Kozubayev North Kazakhstan University, Petropavl, Kazakhstan. The dissertation is being submitted for defense for the first time. All required documents related to the dissertation have been published on the official website of the Dissertation Council. All members of the Dissertation Council have the relevant materials on the dissertation at their disposal. The defense is being conducted in a live online broadcast format via the internet. When the Dissertation Council holds a meeting in the form of a video conference, the following procedures are ensured: visual identification of all participants, uninterrupted video and audio translation of participants' speeches by the internet, video and audio recording of the meeting, confidential secret voting by the members of the Dissertation Council, participation of the official reviewers and temporary members of the Dissertation Council in the defense and is mandatory. Are there any recommendations regarding for the agenda? No? No, thank you. If there is no any, I will put the approval of the agenda to the vote. Who is against? No? Who abstained? No abstentions. Who is in favor? Okay, thank you all. The agenda is approved by consensus. Now, I give the floor to the Academic Secretary of the Dissertation Council, PhD, Associate Professor Kamar Aldasheva, to present the candidates' biographical information and documents from the personal file.
Good morning, dear members of Dissertation Council. The documents of candidate Toksanbаева registered with the Dissertation Council are as follows. The first is a candidate's application for admission to the dissertation defense was approved by the Dissertation Council on 15 August 2025 and recorded in the registration journal. Second, the dissertation bound and on an electronic medium, and the information about the doctoral student. Токсанбаева Рахия Куантхановна, nationality Kazakh, born on October 14, 1982 in Aralsk. In 23, she graduated from Kazakh Humanitarian and Law University with a bachelor's degree in jurisprudence. In 28, she graduated from Cornell Law School at Cornell University with master's degree in law, and in 2020 she graduated from Al-Farabi Kazakh National University with a master's degree in foreign philology. From 2020 to 2023, she completed the professional curriculum of doctoral studies at Al-Farabi Kazakh National University under the educational program 8D 2306 foreign philology. She currently works at Kiev University as a senior lecturer. The second document, a copy of the transcript of the professional curriculum approved by the educational institution, and the reviews of local and foreign scientific advisors, and a copy of the visit sheet and the minutes from the extended meeting of the Department of Foreign Philology and Translation Studies at KAZNO, where the proposal for the defense and the positive conclusion were approved by the Vice Rector for Science and Innovation of Al-Farabi KAZNO. The second document, reviews of the official reviews, and a certificate from the National Center for Scientific and Technical Information, and a certificate of submission of the dissertation and its annotation to the Library of KAZNO. The next, a copy of the minutes of the meeting of the Academic Council of KAZNO on the approval of the dissertation topic and the scientific advisors. The second, list of scientific publications signed by the Scientific Secretary of the Faculty of Philology of the Kazakh National University and their copies. The research conclusions and the results were published in three publications in both domestic and international scientific journals. Among these, one article was published in an international peer-reviewed journal indexed in Scopus, 2 articles published in scientific outlets recommended by the Committee for Quality Assurance in the field of Science and Higher Education of Ministry of Science and Higher Education of the Republic of Kazakhstan. The documents submitted by candidate Toksanbaeva fully meet the requirements of the rules for awarding degrees of the Committee for Quality Assurance in the field of Science and Higher Education of the Ministry of Science and Higher Education of the Republic of Kazakhstan. Thank you.
Rahia Konkanova, beginning. Microphone.
Esteemed members of Dissertation Council, respected faculty, and fellow PhD students, it's both a pleasure and honor to present my dissertation, which was completed under the supervision of my domestic supervisor, Dr. Kulakin Jahanova, and my foreign supervisor, Professor and Dr. Anastasia Zaborska. So first, I will briefly outline the aims, objectives, methodology, and sources and main findings of my research. So the aim of my work is to examine the linguistics and cognitive characteristics of legal discourse. The objectives are to examine the vagueness in UK Parliamentary Acts through the by testing the Hart's theory. The second objective is to investigate polysemy in legal discourse in legal language, focusing on how general terms acquire specific legal meanings. And then the next objective is to explore cognitive mechanisms of legal interpretation through frame semantics and Barcelona simulation theory. And the last objective is comparative analysis, which is to analyze instances of polysemy in Kazakh legal texts, such as the Civil Code, Criminal Procedure, and the Labor Code of the Republic of Kazakhstan. So I'll just, this is my dissertation. Our dissertation is structured to correspond each of the objectives. And as you can see here, the first chapter is on theoretical foundations, and then the second is discusses the vagueness, and the third one focuses on the polysemy. So here, since we are studying the linguist semantic and cognitive characteristics of the statutory language, we've chosen three Parliament acts of Parliament, which are Consumer Rights Act, Employment Rights Act, and Criminal Justice Act. All of them are available for public domain through their websites. And then for comparative analysis, we've chosen Criminal Procedure Code, Labor Code, and the Civil Code here. So methods are lexical semantic, discourse analysis, frequency analysis, cognitive, and comparative analysis. These are the statements submitted for defense. I'm not going to read them and focus on them because I'll be discussing them in the key findings and the conclusions of our study. So, well, first, we'll present two conclusions or two key findings for each chapter. First, we will discuss vagueness in statutory language. Before that, I would like to introduce you to the outline that there are two major systems, legal systems in the world. One is civil law legal system, which Kazakhstan belongs to, and the other is common law legal system, which it belongs to. So civil law legal system relies on codified law. And in England, there are two sources of law. One is law made by judge based on judicial precedent, and the other is acts of parliament, which we also call statutes. Acts of parliament is a supreme law. So historically, common law legal system is based on codified law, but they have been moving forwards, codifying their laws and creating this body of statutes. And in our study, against this background, our research sought to examine whether Hart's famous theory of open texture, first introduced in 1958, still remains relevant and can be observed in this contemporary UK statutory language, because historically the law in the UK has been oral, and how did they manage to put that oral language into the status of the UK? Open texture theory suggests that laws will inevitably contain vague terms, so leaving some space for judicial interpretation. And to test this, we analyzed three statutes that I just mentioned, enacted over the past 3 decades, each representing different fields of law. So we have Employment Rights Act here, Criminal Justice Act, and Consumer Rights Act. And as you can see, we have presented here this figure where you can see examples of the vague terms that were found in these acts. Our analysis found that vague terms appear consistently across all these 3 acts, with many of the same terms recurring each, and then there's some terms predominant in one act, and then they may not even exist in other acts. For example, the term leave is more predominant in the Employment Rights Act due to its subject matter. The findings indicate that vagueness is not incidental, it's not random, but it's actually systematic and functional feature of legislative drafting. It allows statutes to remain flexible and adaptable to unforeseen future circumstances, thereby highlighting that the value of HART's insight and the relevance of the HART's open texture here, period. So we've provided an example here. As you can see here in this section, which was found in Employment Rights Act, we can see more than one vague terms. Reasonable belief in the public interest tends to show miscarriage of justice is likely to occur. So it is not clear what reasonable belief is, how much reasonable should be to consider the belief reasonable. Or so this is a nice illustration of combination of vague terms. So drafters, they structured within a coherent framework more than one terms. Instead of relying on a single term, they introduce part test using other flexible terms. This gives a clear set of evaluative criteria for the judiciary. So here, if we look at the phrase reasonable belief, we can see the illustration of a theoretical paradox. Theoretical means that there is this sliding scale, like a continuum. On one end, we have completely unreasonable. On the other hand, we have perfectly unreasonable. And there is no set boundary in between where we find the reasonable belief. So this is also yes. And then this, like we just mentioned, these also the some sort of controlled vagueness as well, because one vague term serves as a filter for another vague term in order for the second section to work. So, so here, the next key finding is that these vague terms empower states and judges. So vague terms or open-ended terms are also deliberate drafting choice to empower decision makers, particularly judges and administrative officials, to adapt law to context. So we provide an example here, as you can see on the right side. So in this example, we see words like believes on reasonable grounds, significant risk, and serious harm. So here, all these three acts reveals the systematic use of mental state verbs such as believe, is satisfied with, in opinion of, and think, along with the evaluative language, along with the open texture words, words like reasonable, significant, serious, like it's present in this example. So institutional actors are required to engage in mental assessment of abstract notions, of vague terms. So this section is an illustration of epistemic authority, which employs that phrase beliefs on reasonable ground, illustrates the interplay between modal verbs, mental state predicates, and vague qualifiers. So we can also see subjective modality here as well, because it's allocation of interpretive power and the underlying institutional hierarchies are both enacted and reinforced through the language. So the conclusion for the chapter 2, where we discuss vagueness, is that vagueness definitely emerges as a pragmatic institutional tool, balancing certainty with adaptability and ensuring status remain responsive to evolving context. Yes, the HART's theory is still relevant. The vague terms are used to keep the social the control of the society, but one more thing is that we would like to add here is that it's more than that. It's the basis, it's the cost that we pay, the cost that the common law legal systems pay to allow greater scope for the protection of human rights and individual freedoms. It also ensures that all citizens have equal opportunity to present evidence and to challenge interpretation of legal terms. This safeguards the principle of equal justice, avoiding rigid rules that could account for diverse and unforeseen circumstances. So citizens have this guarantee that they not only have a 50% chance of losing, but they also have a 50% chance of winning the case, because they can interpret, because this flexible language gives them that opportunity, which we unfortunately don't have in our legislation, in the codified legal system. So then now next I want to move to our next key finding, which is a chapter, third chapter where we focus on polysemy. So of course, in legal context, we cannot always use legal terms or terms of art. Terms of art are technical legal terms, but we also have to rely on the ordinary language. So because the language is not limitless. So we sought to investigate whether the use of ordinary or polysemous terms gives rise to confusion and ambiguity. So our conclusion was that ordinary terms are often used in legal senses, but usually no confusion arises because in common law legal system, they function as terms of art or appear in fixed collocations. So we provided examples here. As you can see here, we have the word leave. So in a general language, we all know what leave means, go away. But in a legal context, in collocation with other words, it has a totally different meaning. And across different acts, their meanings also change. For example, in the Criminal Justice Act, we have this section where it says, with the leave of the judge. So a lay person, a person who is not a legal professional would not understand this section without having the legal knowledge, because leave of the judge is an archaic term that dates back to Middle English, and which means judicial permission. So it's when the court gives the permission. It's still used, although they're trying to reform it and move to using more simple language, the plain English, but it's still used in the act here. Then we also have a claim damages, bring a claim. We all know what these terms mean in the general English separately, but together in a collocation they indicate a legal term. And a legal term, claim damages means seek for monetary compensation, and bring a claim refers to bringing a lawsuit, to filing a lawsuit. So next is, what we want to mention is the Cruz's collocational model to reinforce what we just discussed in the previous slide. So we've tested Cruz's collocational model in a legal context to demonstrate how meaning is clarified and stabilized through collocation. So there are like 5 factors that shape collocations in that were offered by Cruz, but we've only outlined here. I'll only mention the 2 of them. One of them is arbitrary collocation restriction. So there doesn't have to be a logic in why these words are put together. So we have a charge and other security. We all know what charge means. We know what security is, but probably for most of you, it's not clear what it means, charge or other securities. So here, this is a specific legal instrument that is used in secure transaction. Even the phrase secure transaction has a legal meaning because it's a transaction that's backed up, supported by the collateral. And so these examples, with the examples from previous slides, they all demonstrate that legal polysemy in a legal context is not random, it's not chaotic, it's actually systematic, it's systematically regulated by grammatical structure, institutional context, and interpretive conventions. In this sense, polysemisters enrich legal vocabulary, allows small set of familiar words to carry multiple technical meanings. So, key finding that we would like to outline here is on the comparative analysis. We didn't focus on this a lot. We only there's only like 1 subchapter in a chapter 3. It's because our topic is focused on the materials of English language. So we didn't aim to do comparative analysis, but we've decided to mention it because we live in Kazakhstan and we have AIFC in Astana, which employs English law, so common law legal tradition. And we also have a large number of international law firms in Kazakhstan where lawyers work in English, but they have to deal with the codes and laws in Kazakh and Russian. So they also involved in this translation process on a daily basis. There's no official version of English version of codes in Kazakhstan, so each law firm has their own translations, so which can sometimes be misused and which can be translated to their benefits. So here we examined to the polysemy in these words, because when we translate terms from English into Kazakh, most of the time we end up like you see in this example, using the same term for different, as an equivalent for different English terms. Like here, we use kshinjoyu for like at least, and this is not the full list here, 1, 2, 3, at least 6 words, right? So, but some of those words are pretty, have a narrow meaning in English, whereas in kshinjoyu can have a broader meaning in Kazakh. So the other word, for example, buzu is also, as you can see, can be equivalent to many other English terms. Again, some of the terms are very technical in English, and they always go in collocation with certain terms, which doesn't always happen in our system. I mean, in our legislation. So, so we wanted to draw attention draw attention to one point here. If in the common law legal system, the use of polysemy does not lead to confusion and ambiguity because they rely in terms of art and fixed collocations, in Kazakh language, it actually leads to ambiguity because we use same terms for different concepts. And sometimes even the contextual cues does not help us understand whether it is what it means without it, looking at the Russian version of those laws. So in conclusion, our study reinforces and updates the HART's concept of open texture by testing its validity in contemporary statutory language, which hasn't been done, demonstrates how vagueness and polysemy function as deliberate drafting strategies, ensuring both stability and adaptability of law. It highlights the challenges of translation-induced variability in Kazakh legal discourse, highlights the contributing to comparative legal linguistics, provides tools for improving clarity in legal drafting, translation and interpretation, supporting the legal certainty and accessibility, and bridges linguistics, law, and cognitive science, offering methodological foundation for future research in institutional discourse. Thank you very much for your attention.
The presentation has been concluded. Thank you, Rahia Vankanovna. Dear members of the Dissertation Council, please feel free to ask questions for the candidate. Dear colleagues, questions?
May I ask a question?
Yes. Okay.
Yeah, I am Metin Ekici. I'd like to thank you, Rahia Toksanbayeva. And my question is about how did she selected the English text for using as a material for the dissertation? Thank you.
Thank you.
Thank you for your question. Yes, we've taken codes, like laws from the past 30 years and from 3 different decades. So we wanted it to be laws, and they're pretty large and major laws. They're important laws in the UK, and each law is like 400, 600 pages, and each act is from a different domain. So we have from employment law, from a consumer law, and also from a criminal justice sphere. So all of these come from 90s, from 2000, and the newest one from 2015. So we wanted it to be from a different time and different domains.
Thank you very much.
Thank you. Thank you, Metin Kocam. Next question. No questions?
May I ask a question?
Okay. Yana Alexandrovna.
So my question is about the thank you for a very interesting presentation, but my question is about the methodological approach. So you talk about cognitive theories, and you base your work on cognitive theories, frame semantics, prototype theory, simulation theory. But what specific advantages do they offer compared to traditional lexicosemantic analysis of legal language? Is the question clear?
Part of our, so lexical semantics, in lexical semantic, we've analyzed the text. In lexical,
Uh-huh.
for the lexical semantic approach, we've analyzed the text of our of the acts to, and most of it I did manually to select those terms, and we also used software, Langsbox as well, to select these vague terms. But we also supported it with the cognitive approach, which is like frame semantics and the Barcelow's the perception of perception of symbols, because we wanted to show that how this mentally assessed by the legal profession, these terms, like these vague terms. So these are three different approaches that we've taken to conduct this research and to because for lexical approaches used to find the words. For example, we found for the polysemous word duty, and then we did the cognitive assessment of the word duty. For example, how it is. Frame semantics means that lawyers, legal professionals, they have to retrieve some background knowledge, right? So they don't only rely on their personal knowledge, but they also rely on professional knowledge. So, for example, transactional lawyer, when they encounter the word duty, the first thing that they would interpret this term with, they will associate with the duties that come out of transactions. And the litigators would, for example, if they're in tort law, they would associate it with the duty of care. So even in a legal context, they might have different meanings. And it was interesting for us to see like how this what simulators are activated when the lawyers, legal professionals, they encounter certain legal terms and different legal contexts.
Thank you.
Yana Alexandrovna, next question. No?
Actually, I do have one question, but it's more about the terms. So you are, according to your presentation, you pay attention to their polysemy of legal terms and their interpretation. So how do you suggest defining between polysemy and terminological ambiguity in legal discourse?
Thank you.
Actually, that's my last and second question and last question.
Thank you for your question. Yes, so in a legal context, actually polysemy is studied because it is considered that polysemy actually leads to ambiguity. So using polysemous word, so we distinguish between vagueness and ambiguity. Sometimes some people, they confuse these two words, but they actually mean different things. So vagueness is when it's not, the meaning is not clear, but polysemy is when it has more than one meaning. So sometimes when, as you know, we have this the word leave, right? We presented the term leave, and then we know that leave of court has a different meaning. Maternity leave, which has also different meaning. So here we can see that these, because they're used in collocations and terms of art, there's ambiguity is not does not happen much in a legal context in a common law legal system. So basically, polysemy at least in a legal linguistics, polysemy is studied in a context of ambiguity.
Thank you very much for your answer.
Can you repeat the first question? think the first question is kind of related to what I've just explained. Cognitive, like I said, frame semantics and the Barcelow's model are relevant for the legal interpretation, because that kind of helps us to see that the importance of the background knowledge in interpreting terms. And the Barcelow's theory actually complements that by showing that which attributes and which values shape that interpretation. For example, in a legal context, if we go back to the example of duty, like what are the attributes, like who are the actors that use these terms, like the types of lawyers, and if we refer to the values, like is it a civil litigation, is it a criminal litigation? So how all this helps us to understand the meaning, the different meanings of the terms in different legal contexts and by different legal professionals. So how many terms? For the polysemy, we've examined 10 terms, but we did an in-detail examination of those 10 terms in English, but there were less terms in Kazakh because we didn't focus on the Kazakh language. For the vague terms, I don't know the exact number because we did a more like a lexical semantic
Рахия
analysis.
Куанхановна, микрофон.
Because we focus on the lexical semantic analysis rather than the frequency analysis. The frequency analysis was done, like I said, using the Langsbox software for the polysemy. So yeah, and the third question, the benefit of cognitive analysis is because we like I mentioned, we belong to two different, mentioned the translation, because we belong to two different legal systems. So of course it is important because when we are translate again, like I illustrate in examples, when we translate from English into Kazakh, it's really important to understand the legal concept, because we cannot just literally translate the terms, and we cannot, but we end up using the common terms, right? Ordinary terms. And when we're doing ordinary terms, we have to make sure that the meaning is not lost in translation, in the process of translation. So this is something that we haven't focused much in our dissertation, but I think this is something that we could be considering in our future publications as well. So delving deeper into this analysis. Yeah. For the polysemy, we've examined 10 terms for polysemy. For vagueness, we didn't do frequency analysis for the vagueness.
Dear colleagues, next question. Okay.
Разрешите задать вопросы на русском языке, мне так удобнее будет. Уважаемый диссертант Рахия Куанхановна, у меня к вам небольшие вопросы, просто заинтересовалась, потому что сейчас я еще хочу выступить по политическому, по юридическому дискурсу. Вот вы в своей работе, конечно же, останавливаетесь на таких терминах, как неопределенность и полисемия. Вы даже там привели вопрос, но я потом маленький вопрос еще задам. Скажите, пожалуйста, вот в параграфе, у вас есть специальный параграф, где вы рассматриваете, даете сравнительный анализ, да? Сравнительный анализ. И вот в этом параграфе, где вы делаете анализ парламентских актов Англии и казахстанских юридических текстов, вы почему-то больше внимания уделяете полисемии. Почему не, где тогда остается ваш второй термин неопределенность?
Okay, thank you very much.
So thank you very much for your presentation. And my first question is, according their terminology, according to the terms vagueness and polysemy, as you have mentioned in your presentation, that the comparative analysis in the UK Parliament and in Kazakhstan situation. So how do you make it look?
Can I answer in English and he will translate, right? I'll try. Yes, we focused on polysemy. We did not even focus on vagueness. So probably some of you think whether we have vagueness in our legislation. We do have, but not to the extent that Parliament Acts has.
Да, мы основываемся на неопределенности, тем не менее, да, но хотелось бы сказать то, что, значит, непосредственно эти сами параметры, они указаны в всех информациях.
vagueness, я имела в виду, что vagueness у нас, может быть, вам интересно узнать, если у нас vagueness, в нашем законодательстве есть vagueness, неопределенность, но только не в таком объеме, как English legislation. And what I want to focus on here is that vagueness, when we examined criminal procedure code, vagueness appeared like one or twice. For example, по внутреннему убеждению was the only explicitly vague term, but we didn't focus on because polysemy is more important for us. And I'll explain why. So there is a subsection in our dissertation which discusses translation. And some people think that this dissertation is about focusing on translation. That's not just about translation. It's actually bigger than translation. It actually demonstrates us the problems we have in our legislation. So it shows us that we need a set of, probably we need to reform our legislation, and we need a set of terms of art, or at least fixed collocations, because our laws are written in Russian. Most 90% are written in Russian.
Да, хотел сказать, значит, когда мы изучали уголовно-процессуальный кодекс, неопределенность, именно терминология, термин неопределенность встречалась 1 или 2 раза. Например, значит, внутреннее убеждение было единственным явно неопределенным термином, но мы не сосредотачивались на нем, потому что для нас более важна полисемия. И я хотел бы, с вашего разрешения, объяснить, почему. В нашей диссертации есть подраздел, который посвящен переводу, и некоторые как бы думают, что эта диссертация посвящена именно переводу. Но на самом деле это не только дело в переводе. На самом деле это более шире, более глобальнее, чем перевод. И наглядно мы демонстрируем все проблемы, которые существуют в нашем законодательстве.
Yeah, it demonstrates the problems we have, that we need terms of art because those laws are written in Russian, translated in Kazakh, and of course they're not written at the same time, in different times, right, by different translators. What we have here, each translator, they offer their own equivalent, and then we have this ambiguity that we mentioned in our presentation.
Thank you. У меня небольшой еще второй вопрос, если можно. Вы, как известно, слышно, да, в мировой судебной практике, очень есть такие при толковании вот норм законодательства с так называемой open texture, и еще бывают еще расплывчатые, да, формулировки в документах нормативных. Скажите, вот в практической деятельности, вот есть ли инструменты и стандарты, которые позволяют ограничивать судебные, вот сейчас скажу, как это, мнения, что ли, субъективные судебные, они же бывают, еще часто бывают, да, и какие-то личностные предубеждения. Как вот этого избежать?
Один вопрос повторите, я переведу коллегам. Вкратце, один вопрос. Просто повторите, пожалуйста, я переведу коллегам. Да. Один вопрос на английском.
Как избежать в практической деятельности, есть ли какие-то инструменты практической деятельности или какие-то выработанные стандарты, которые позволяют ограничивать вот эти судебные субъективные объективность судей, еще, конечно же, какие-то личностные предубеждения.
Are there any practical experiments and any practical measurements and activity in order to avoid such kind of, this is like a juridical and justice subjection objections, if we of course, according due to the world practice?
Thank you for your question. Yes, of course, that's why we have a judicial precedent. So when they decide their cases, judges, they rely on previous cases decided by other judges. So if there is a similar case, they have to rely. For example, let's say someone was dismissed from a job for being late for 2 hours. So is that 2 hours considered reasonable? Reasonable is a vague term, as we know. So what we do is we look at the same case where someone was dismissed from the work for 2 hours, and we apply that similar case to this case. And then nobody can argue that the judge misinterpreted and we call them actually tests. So usually those important rulings in cases are called tests, that they are the judges have to base their decisions on. And there's also a checklist of qualitative factors, framework for judicial reasoning, right? Like we mentioned this in those sections. We don't have just one big term. We have more than one big term, and those each term is like a filter for other term. They control the other term. And a theoretical paradox that I mentioned, that for example, Diana Ruffman says that there doesn't have to be a right or wrong answer. So if someone says that reasonable is not 2 hours is not reasonable, and the other judge says 2 hours is reasonable, both answers can be accepted because we have this continuum, and anything in between that continuum can be accepted as a correct answer.
Okay, thank you. Next questions? No? Anna.
Рахия ханым, мына жерде сіз қазақ тіліндегі заң мәтіндерінің мысалын келтіру деп диссертацияңызда бір мақсаттың бірі деп жазыпсыз.
So when you have indicated in your presentation, like in Kazakh language, some Kazakh terminology.
Қазақстан заң терминдерінің полисемияға қатысты мысалдарын анықтау деп.
Law terminology for the policy.
Yeah, осы тұста сіз диссертацияңызда берген материалдарды мен қарадым. Әлде басқа да материалдар бар ма? Сосын анықтау мақсатыңыз болды ма? Жоқ, оның полисемияны анықтаған кезде оның себептерін түсіндіріп көрсеттіңіз бе? Әлде болашақтағы жұмысыңыз ба осы мәселе?
You talk about more about polysemy, about the explanation and what kind of other materials were based on your dissertation presentation.
Біздің заң мәтіндерін жетілдіру үшін, заң мәтіндерінің дәлдігін
In order to improve and to develop about Kazakhstan, the law.
Қандай пайда бар? Соны білгім келіп тұр. Рахмет.
I'd like to know about in general. Could you clarify this, please?
Okay, sorry. Thank you for your question. Yes, I've actually written an article on this. It was published this year. It's about actually polysemy in civil code, and where I discuss whether these terms, chaotic use of terms in our civil code are the problem of translation, or is it a polysemy? So yes, so we should be doing. We are planning to do further research on this and write another article focused on the synonymy as well.
Okay, thank you. Қазақша.
Иә, әрине, дегенменен осы ұғымдарға жаңағы қатысты біз келешекте болашақта өзіміздің жоспарымызда дегенменен жаңағы зерттеуге саламыз, және де әрмен қарай тағы да осы ұғымдарға сәйкес менің мақалам жазылған болатын және жарыққа шыққан болатын, және де менің ойымша біз келешекте жоспарымыз айқындай айтатын десек, келесі зерттеуімізге дәл осы жаңағы сөздер мен ұғымдарды зерттеуге тырысамыз.
Рахия Қуантқанова, менде бір сұрақ бар. Дәл сол мысалдарды айтып кетесіз бе қазақ тіліндегі? Қандай көп мағыналы тілдік бірліктер бар? Мысал келтіріңізші.
Could you give us some examples here about the different examples on the Kazakh language according to your dissertation?
The one that we've discussed in our dissertation was usunu, that has multiple meanings in different contexts. But also we had another term that I also discussed in the article was talab koyu, is a very confusing legal term because it's presented as filing a lawsuit, but it's also presented as iskovaya davность. But these are two different legal concepts, and they're two different meanings, but we use the same term within the same article of the civil code, which I think is not acceptable. And the civil code, the Kazakh version of the civil code has to be reformed.
Микрофон поближе, пожалуйста. Next questions? No? I have questions. Okay. What is it primary and secondary legal text? What is specific? One question.
The primary text here, for example, in English legislation, the primary text is basically the acts of parliament. This is the primary text, and this is actually the supreme text. There's no text above that acts of parliament. They don't have a written constitution. Secondary sources secondary sources can also be the acts of what do we call it? Statutory instruments. Yeah, in English legislation, we have statutory instruments that are adopted by for example, Ireland, Scotland. But if we talk about the secondary sources that, for example, judiciary, they can rely not only on the acts of the law, but judiciary, when they decide a case, they can also rely on articles, which can be surprising to us. They can rely on other like dictionaries. Sometimes if the word is not clear, the meaning of the word is not clear, they actually rely on the meaning presented in the dictionaries. Yeah.
Okay, thank you. What is the meaning and features cross-linguistical and cognitive analysis?
I couldn't hear it.
Meaning and what is meaning and features cross-linguistical and cognitive analysis? Cross-linguistical.
Oh, when we analyze the text across the two different systems,
Linguistical, yes.
and then cognitive is when we look at the mental representation of the terms.
And what can you say about challenge during of the research work?
Challenge.
Yes, challenges during of the research work.
It's an interdisciplinary field, right? And then when we deal with the legal discourse, we have to a lot of work, the documents, a lot of sources are actually confidential, right? So first we were thinking that focus on the contracts, but we couldn't do it because it's confidential, and it was really difficult to access the judicial decisions. And then it took us 2 years before we could find the best materials for our research, and we eventually focused on the text of law because laws are available, and they're also is for the whole population and are really have a high significance.
Thank you, Mayra Iringaipo.
Thank you very much for your presentation. My question is, why have you chosen this particular theme for the research? Yeah, why have you chosen this particular theme for the research? And what was the main criteria of choosing this material for the research?
Thank you for the question. Yeah, well, it's the reason is because of my legal background, because I have my bachelor's in law. I also have master's in law, and I also teach legal English. And to be honest, I use most of this material in my classes. They're so useful for my classes as well. And then, like I just mentioned, that legal materials are confidential, right? The contracts and judicial decisions are really difficult to access. That's why we had to look for something that is in public domain. And then we've chosen acts, and then and we find it, and it also has a significance for the population as well. So we thought we can do a bigger job on this.
Okay, thank you. Thank you. Dear colleagues, questions? Okay, enough. Dear members of the Dissertation Council, if there are no questions, the next item is a reading of the reviews by the candidate's domestic scientific advisor, PhD, senior lecturer, Al-Farabi Kazakh National University, Kuralay Kinjikhanovna Kinjikhanova.
Thank you.
Sit down, please.
Good morning once again, the head of the dissertation committee and members of the committee. Let me just present my review for the dissertation research of Rahia Toksanbaeva on linguosemantic and cognitive characteristics of legal discourse on the materials of the English language submitted for the degree of Doctor of Philology, PhD on educational program 8DO23006 Foreign Philology. The dissertation of Rahia Toksanbaeva represents a methodologically rigorous and theoretically significant scholarly work that examines legal discourse through integrated linguistic, semantic, and cognitive approaches. The research addresses fundamental questions concerning how meaning is constructed, interpreted, and negotiated within legal texts, with particular emphasis on the phenomenon of vagueness and polysemy in statutory language across English and Kazakh legal systems. The study uniquely combines theoretical insights from critical discourse analysis, legal linguistics, and cognitive science, with empirical evidence from legislative acts of the United Kingdom and Kazakhstan, offering valuable cross-linguistic and cross-systematic perspectives. One of the dissertation primary analytical contribution lies in the systematic treatment of vagueness as a structural and functional element of legal language. The researcher conducted detailed analysis of statutory provision from the Criminal Justice Act, the Employment Right Acts, and Consumer Rights Act, identifying the categorizing and determinate expressions. The researcher's exploration of polysemy significantly enriches understanding of how ordinary language terms acquire specialized legal meanings through context-dependent cognitive processes. Through systematic application of frame semantics and prototype theory, the dissertation illuminates meaning construction mechanism for common legal terms such as action, duty, charge, and claim in British statutory texts. The researcher demonstrates that polysemy in legal discourse operates systematically and functionally, with meaning shifts influenced by grammatical form, statutory context, co-occurrence patterns, and pragmatic requirements. The research extends this analysis to Kazakh legal texts with adoption of everyday vocabulary for legal purposes, as well as the influence of Russian and the increasing use of Anglicism results in the higher degree of polysemy and context dependence compared to the more differentiated legal lexicon of English. The sociolinguistic survey conducted among legal professionals in Kazakhstan provides empirical support for this observation, revealing both the pragmatic motivation for adopting Anglicisms and the challenges they pose for legal clarity and translation. And then I'd like to just pay attention to the question connected with Kazakh terms and borrowings, and also the question connected with polysemy in Kazakh civil code was just presented as a scientific article which was entitled like Problems of Adaptation of Borrowings and Excessive Use of Borrowed Words in the Civil Code of the Post-Soviet Country on the examples of Kazakhstan, which is the question, which is the main question asked before, yeah? And then as a result was delivered not only in the article, but was delivered in the US at the California University among students and among teachers in order to share this expertise not only in Kazakhstan, but also in foreign countries as well. And also, the scientific novelty of the dissertation lies in the systematic integration of cognitive linguistic theory with legal discourse analysis combined with the innovative comparative English-Kazakh perspective. The research successfully reframes vagueness and polysemy as essential rather than problematic feature of legal language, contributing significantly to ongoing theoretical debate about determinacy and judicial discretion in legal interpretation. The dissertation research of Rahia Toksanbaeva entitled Linguosemantic and Cognitive Characteristics of Legal Discourse on the Materials of the English Language is marked by the scholarly rigor, theoretical innovation, and practical relevance. The work exhibits methodological sophistication through its interdisciplinary approach and comprehensive analytical framework. The research marks significant contributes to legal, linguistic, comparative law, and foreign philology, offering both substantive scholarly value and practical application for legal education and practice. In conclusion, the researcher Toksanbaeva Rahia has fully achieved the objectives set forth in her dissertation work, producing a completed, comprehensive study that has reached its intended goals. I consider that the dissertation complies with the requirements of Section 2 of the Regulation for Awarding Academic Degrees of the Committee for Control and Education and Science of the Ministry of Education and Science of the Republic of Kazakhstan. And I believe that it's also Toksanbaeva Rahia fully deserves to be awarded the academic degree of Doctor of Philology PhD in the educational program AD 0230006 Foreign Philology. Thank you for your attention.
Anastasia, please.
Do you hear me?
Yeah, okay.
Yes, thank you. So now I will read Foreign Supervisor's opinion on Rakhia Toksanbaeva PhD thesis, Linguosemantic and Cognitive Characteristics of Legal Discourse on the Materials of the English Language, which is today under consideration for the PhD degree. It has been a pleasure to supervise a PhD thesis that stands out for its scholarly rigor and interdisciplinary depth. I commend Rakhia Toksanbaeva's PhD dissertation on linguosemantic and cognitive characteristics of legal discourse on the materials of the English language for its nuanced integration of legal linguistics, semantics, and cognitive science. The research presents a comprehensive and well-structured investigation into the complexities of legal language, focusing on polysemy, vagueness, and interpretive challenges across English and Kazakh legal texts. The dissertation is methodologically organized and impressively detailed, maintaining academic integrity and linguistic precision throughout. Each chapter contributes meaningfully to the overall argument, offering original analysis and insights into legal discourse as both a linguistic and cognitive phenomenon. Rakhia skillfully engages with a wide range of theoretical frameworks, from classical discourse theory to contemporary approaches in cognitive linguistics and critical discourse analysis. This work holds special significance within the context of Kazakhstan's evolving legal and linguistic landscape. As Kazakhstan continues to modernize its legal system while coping with its multilingual realities, the thesis provides timely and valuable perspectives on how legal meaning is constructed, communicated, and translated. By comparing British and Kazakh legal texts, the research illuminates challenges in translation, legal drafting, and terminological precision, all of which are crucial for legal clarity and institutional trust. The thesis is distinguished by theoretical novelty and practical relevance. It proposes informed approaches to resolving semantic ambiguities and stresses the importance of cognitive and contextual factors in legal interpretation. The empirical analysis grounded in British and Kazakh legislative acts are systematic and insightful. They offer practical implications for legal education, translation studies, and policymaking. The quality of the writing, analytical depth, and adherence to academic standards are commendable. Rakhia Toksanbaeva has demonstrated high scholarly competence and intellectual independence throughout the process. I'm confident that she will defend her dissertation successfully and make a meaningful contribution to the fields of legal linguistics and discourse studies. Thank you for your attention.
Thank you, dear Anastasia. Dear members of the Dissertation Council, we now give the floor to the two official reviews. The floor is given to candidate of philological sciences, associate professor of the Caspian State University of Technology and Engineering, named after Isenova, Isakova Asılmay. Please.
Dear members of this station, can see the works. Oh, okay. Dear members of Dissertation Council, let me inform you with the review of the official reviewer for the dissertation work, Rahia Toksanbaeva, on the theme linguosemantic and the cognitive characteristics of legal discourse on the materials of the English language, presented for the degree of Doctor of Philosophy. Doctoral student corresponds to the priority area research in the field of social and the human sciences, approved by the Higher Scientific and the Technical Commission under the government of the Republic of Kazakhstan. The dissertation was completed in accordance with the concept for the development of higher education and the science in the Republic of Kazakhstan for 2023 and 2029. The work makes a significant contribution in science and its importance is well disclosed. Doctoral student presents a deep and well-founded analysis of legal language. The study offers valuable insights into how meaning is contracted and understood within legal discourse, combining linguistic and cognitive approaches. By focusing on English language legal materials, the author highlights practical implications for legal interpretation, translation, and communication. The relevance of the research is clearly explained, and its theoretical and practical significance is convincingly justified. Dissertation demonstrates a high level of independence, which is confirmed by the research results obtained and tested in a number of the author's publications, as well as by the absence of any borrowing from other sources. The relevance of the thesis is well justified. The study addresses an important aspect of linguistic and cognitive analysis by exploring the principle of unity within legal discourse. In legal communication, coherence and semantic consistency are crucial for accurate interpretation and the effective application of the law. The purpose and objectives of the thesis clearly corresponds to its topic. The main purpose is to investigate how linguistic and cognitive features shape legal communication in English. This is supported by special objectives such as analyzing key semantic and syntactic structures in legal texts, identifying typical cognitive models used in legal discourse, for example, conceptual metaphors like law is in pass or justice and balance, classifying legal terminology based on its semantic roles. The thesis demonstrates a clear critical analysis by comparing the author's proposed
approaches with existing theories and methods in the field of legal discourse. For example, the author introduces a modified classification of semantic ambiguity in legal texts, which goes beyond traditional linguistic frameworks by incorporating cognitive and contextual variables. The scientific results presented in the thesis are completely new. The research offers original insights into the field of legal discourse by introducing new classifications, analytical models, and interpretations. These contributions significantly advance current understanding of semantic ambiguity and polysemy in legal texts and go beyond existing theories in linguistics, cognitive science, and legal language studies. For instance, the cognitive semantic framework developed by the author for analyzing legal discourse introduces new perspectives on how legal meaning is constructed and interpreted. This framework integrates legal pragmatics, conceptual metaphors, theory, and the frame semantics, which have not previously been combined in the same way within this context. The content of the doctoral candidate's publications aligns with the topic of the dissertation. However, the number of publications appears to be limited, expanding the scope of research dissemination, particularly through presentations in international conferences and the publications in peer-reviewed journals would further strengthen the approbation of the dissertation finding and enhance their academic credibility. So these remarks do not diminish the overall positive evaluation of the dissertation. They are of recommendatory nature. To petition the committee to award the doctoral student Rahia Toksanbaeva Kontkanovna the degree of Doctor of Philosophy in the education program AD 02306 Foreign Philosophy. Thank you very much.
Rahmet, thank you very much, Asılmay Sagınbekovna. To respond to the review's comments, the floor is given to Rahia Kontkanovna. Rahia Kontkanovna.
Thank you for your review. I really appreciate your time and effort put into it. And yes, you've just mentioned that my publications were limited, and then that would raise the approbation of my work. I agree with that. It's because my field is interdisciplinary. I had to study both law and linguistics, and it's really difficult to get to publish articles when it's interdisciplinary, because for law journals, my articles are too linguistic. For the linguistic journals, they find my article too legal. That's why I had this challenge, and it took me 4 years to publish my Scopus Index article, and my foreign supervisor also knows it. We attempted so many times to send it to many journals, and but some of my articles are already in publication. One of my articles was accepted yesterday and will be published next year. So I am working on this, and I'm planning to actively publish articles in this field, because this is the field that I specialize in and plan to specialize in more in the future. Yes. And in the review, there were some questions that I want to address. One of the questions was that that my dissertation should have had more practical application of research findings. And I really want to thank you for drawing attention to this point. Yes, my dissertation is mostly theoretical, but the practical value of finding was in examples of cases, some of the cases that I brought. But I agree that dedicated section on practical implications would be this clearer, and because it's we've changed the direction of our dissertation a little bit in the process, so probably that's why we removed that part, but we will be emphasizing that in our future publications. And the other question you had was the placement, the scope of cross-linguistic comparison between English and Kazakh, that there was a recommendation to expand the comparative analysis. And I think we've answered these questions during the presentation, that our topic is focused on the materials of English language, so which is why our primary focus was placed on English legal discourse. The Kazakh material was included in the final section of the dissertation, but was not emphasized because we wanted to remain consistent within the scope of our research. So since expanding Kazakh English comparison is the path I would like to take to develop further. Sorry. Okay, so I agree with that comparative perspective. Deeper explanation is needed, and this is a natural direction for my future publications, and expanding the Kazakh English comparison is actually the path I would like to develop further after the defense. And thank you.
So thank you very much. So, dear members of the Council, Dissertation Council Committee, let me present you with the review of the dissertation completed by Rahia Toksanbaeva, which is entitled Linguosemantic and the Cognitive Characteristics of Legal Discourse on the Material of the English Language. I should mention that the full version of the review was submitted on time according to the requirements, and that's why let me highlight the main points of my review. So the dissertation is aligned with the priority areas of scientific development and the national programs in the field of education. The dissertation has been carried out in accordance with the law of the Republic of Kazakhstan on education and the law of the Republic of Kazakhstan on science. The concept for the development of higher education and science in Kazakhstan for 2023-2029, and the state compulsory standard for higher education, the order of Ministry of Education of the Republic of Kazakhstan dated July 20, 2022, number 1, and the dissertation topic corresponds to one of the priority areas of Kazakhstani science research in the field of education and the science, as approved by the highest scientific and technical commission under government of the Republic of Kazakhstan. So I would mention that the research makes a significant contribution to the development of legal linguistics, cognitive linguistics, and discourse studies as well. By examining vagueness and the polysemy in the UK legislative instruments, the study demonstrates how legal meaning is constructed and negotiated through statutory discourse. A particular strength of the work lies in its treatment of vagueness as a core feature of legal language, demonstrating how the phenomena function as a fundamental mechanism in the creation of legal meaning. And the given dissertation paper convincingly demonstrates how legal concepts acquire different senses depending on institutional context and the discursive practice. Through comparative analysis, parallels are drawn between polysemous legal terms found in British legislative acts and their counterparts in Kazakh legal texts. These aspects of study hold a particular significance for a deeper understanding of the development of the Kazakh legal language. And it's worth noting that in exploring the polysemy and the interpretation of legal terms across various legal systems, the author has thoroughly examined a range of legislative documents, and undoubtedly the dissertation makes a substantial contribution to the study of legal discourse by emphasizing its integrative character within the context of legal communication. And it also promotes the further systematization of legal terminology in the Kazakh language. And moreover, the finding of the study will contribute to the development of both linguistic and legal competence within the field of legal practice. The dissertation demonstrates a high level of academic independence, as evidenced by a thorough analytical review of theoretical sources related to research problem, the clearly formulated research aim and objectives, and the appropriate selection of methods and techniques for analyzing the material under the study. And the relevance of the given thesis is clearly articulated and grounded in foundation research by both foreign and domestic linguists, as well as in regularity legal acts and define priority objectives in the field of legal linguistics, interpretation of legal norms across languages. The given dissertation paper also highlights the factors contributing to the frequent use of polysemous terminology, to the frequent use of in the Kazakh language, when translating from English. And the purpose of the objective and the objective correspond to the topic of the thesis. Well, the next, what I would like to point out, that the structure of the dissertation is built upon clear logical framework aligned with the research objectives, and all sections and provisions of the thesis are logically interconnected. And the given four propositions, I would like they are logically connected, approved, and they are relevant to the topic of the thesis. And the comprehensive analysis of scholarly advancement in the study of foreign legal discourse has enabled the researcher to systematize and classify polysemous legal terms within the key legal codes in the Republic of Kazakhstan. Moreover, the study strengthens the theoretical foundations for the analysis of legal lexicon and lays the groundwork for further systematization and the description of legal terminology in the Kazakh language, an area that remains underexplored to date. The analysis of Rahia Toksanbaeva's dissertation supports the conclusion that the principal research outcomes demonstrate a high degree of originality. The conclusion of the given dissertation research are characterized by scientific novelty and are grounded in a comprehensive analysis of theoretical framework and empirical data, which allows for the proposition of an original conceptual understanding of the functioning of legal discourse. So all major conclusions are supported by substantial scientific evidence, including legislative materials that illustrate various aspects of legal discourse. They are methodologically justified from the perspective of contemporary linguistics, and the study integrates approaches from legal linguistics, semantics, and cognitive linguistics, which collectively define the innovative nature of the research. And the bibliography comprises 215 sources, reflecting a profound understanding of the investigated problem and a solid theoretical foundation of the evidential base. I won't probably mention which materials have been used in your research. They all appropriate and relevant for the to the topic of this thesis, but and concluding, as for theoretical value, I would mention that dissertation research of Toksanbaeva undoubtedly holds theoretical significance. And for the first time, polysemous legal terms are systematically identified and classified within the framework of the key legal codes of Kazakhstan. It represents an original interdisciplinary study of linguosemantic and cognitive features of legal discourse with a particular focus on vagueness and polysemy in the legislative text in the UK and their comparison with the language of Kazakh legal discourse. And the research integrates approaches from legal linguistic, and I'm repeating again, but the quality of academic writing is assessed as high. And then it might be characterized as well-developed scientific style of presentation with appropriate use of meta-linguistic tools. And the conceptual and the terminological framework accurately reflects the subject matter of the research. Citations and references are formulated in accordance with the standards of academic writing. It should be noted that all structural components of the dissertation are logically organized and coherent, and the propositions and conclusions submitted for the defense are well substantiated. Talking about the theoretical and the practical significance of the dissertation research, at the same time, the following remarks of as a recommendatory nature should be noted. One of the central issues that invites scholarly debate concerns the author's choice of the term discourse as the primary conceptual tool in the dissertation. The concern lies not so much in the selection of the term itself, but rather in its consistent application without significant contextual differentiation. On the one hand, the author adheres to the established understanding of discourse as a communicative phenomenon. But on the other hand, the term is occasionally employed interchangeably with the text, language, or genre, which results in a certain degree of terminology ambiguity. This issue is particularly evident in Chapter 2, dedicated to the theoretical foundation of legal language, theoretical framework of legal language, where the term legal language, legal English, and statutory language are used without clear semantic distinction. And in several instances, it appears that the use of the term language would have been conceptually more appropriate and precise in relation to the phenomena under analysis. And it would be desirable for the author to provide a more rigorous theoretical justification for the contextual use of the concept of discourse, particularly in the light of its complex and multifaceted nature. The second, the dissertation under review sets out to investigate the specific features of polysemy as manifested within legislative frameworks of the United Kingdom and the Republic of Kazakhstan. The research is primarily focused on the functional analysis of polysemous expressions in legal texts across both legal systems. Notably, particular attention is devoted to the role of translation as a factor contributing to semantic ambiguity, which frequently complicates the interpretation of legal terms in cross-linguistic contexts. But it would be desirable for the future research to devote particular attention to a detailed examination of the mechanisms through which ambiguity arises as a result of transactional transformation, as well as to explore the implication of such ambiguity for legal interpretation and law enforcement practice. But it should be noted and emphasized that these remarks in no way detract from the overall quality of the research, nor do they diminish the theoretical and the practical significance of findings presented in the dissertation. And the conclusion is that the academic level of publication offered by doctoral candidate Rahia Toksanbaeva is very high, and the dissertation entitled Linguosemantic and the Cognitive Characteristics of Legal Discourse based on the materials of the English language is completed, independently conducted scientific work. Its author, doctoral candidate Rahia Kwanhanovna Toksanbaeva, fully deserves to be awarded the degree of Doctor of Philosophy, PhD in specialty AD02 306, Foreign Philology, Western Languages. Thank you very much.
Thank you very much, Mayra Iringaipana. Please sit down, please. To respond to the review's comments, the floor is given to the doctoral candidate, Rahia Kwanhanovna.
Thank you, Mayra Iringaipana, for your review. I really appreciate your time to write this review. And yes, you raise an important observation. I agree that discourse is a complex a concept, and the terminological clarity is essential. The choice to emphasize discourse was deliberate, since the goal of the dissertation was not only describe legal vocabulary or syntax, it was also uncover the linguosemantic and cognitive mechanisms that shape legal communication. And it's true that in chapter 2, terms legal language, legal English, and statutory language appear alongside discourse. This reflects the layered nature of my analysis. Legal language designs the general object, statutory language points to its subdomain, and legal discourse frames them as embedded in institutional...
Я поближе держите микрофон, пожалуйста.
And yeah, so it reflects the layered nature of my analysis. Legal language designates the general object, statutory language points to the subdomain, and legal discourse frames them as embedded in institutional practice. And I recognize that at times the boundaries could have been drawn more explicitly. The thing is, in Western linguistics, legal discourse is not used as much as in domestic or in Russian discourse, linguistics. Therefore, most of the authors that I cited were from Western linguistics, like 80% of them, and they usually use legal language or language of law. Probably that's one of the reasons why we've been shifting between these terms. But I take this critique constructively, and future revision, I will strengthen theoretical justification for using discourse in this context, while being more precise about when language is a more appropriate term. I hope that answers your question. Yeah. So your second remark, I also appreciate this insightful remark. My work approaches translation primarily as one of several factors influencing the semantic ambiguity in the Kazakh legislation. And I did not analyze translational mechanisms in depth, as my specialization lies in legal linguistics rather than translation studies. So I agree that this is a promising direction for future research. Thank you again.
Thank you, Rahia Kwanhanovna. Sit down, please. Dear members, dear colleagues, we now open the floor for general discussion. Please. Yes. Свободная дискуссия, Ирка. Яна Александровна. Окей.
Thank you for...
Яна Александровна, можно минутку? Тут у нас... Да, немножко. Подождите, пожалуйста.
Да, пожалуйста. Если можно, уберите презентацию с экрана, потому что я вас очень плохо всех вижу, уважаемые коллеги.
Хорошо.
Остановить демонстрацию.
Сейчас удалят презентацию.
Спасибо.
Яна Александровна. Яна Александровна,
Да?
вы можете говорить, сейчас удалят эту презентацию.
Хорошо, спасибо большое. Dear colleagues, I would like first to express my support for this dissertation on their linguosemantic and cognitive features of English legal discourse. I would like to make a comment that in Russian linguistics, the term legal discourse is widely used. And you can just turn to the works of Vladimir Ilyich Karasik, for example, who has written quite an extensive volume on this topic of types of discourse. Okay, anyway, the paper that we have listened to today demonstrates both theoretical depth and practical relevance. The author convincingly combined traditional semantic analysis with cognitive approaches, and that was my first question about actually, such as frame semantics and conceptual analysis. So this methodological synthesis allows us to see legal discourse not only as a system of terms, but also as a reflection of cultural and conceptual models. Particularly relevant is the comparative dimension. By analyzing English and Kazakh, the English and Kazakh languages and legal discourses side by side, the author highlights both universal cognitive mechanisms and culture-specific features. So all these broadens our understanding of how legal meaning is constructed across languages and in fact, enhances the value of study for intercultural, and I would like to underscore that, intercultural legal communication. So I believe that this dissertation makes a meaningful contribution to the study of legal discourse and deserves to be positively evaluated and supported. So thank you very much for your attention.
Thank you very much, Yana Alexandra, for your speech and comments. Thank you. Окей. Ну, орысша болады. На русском можете, да? Жунусова жаңылдық, Мегизбаевна.
Орысша. Нет, не работает, наверное, да? Работает? Так, ну, я хотела сказать в общем, по диссертации Рахии Куанткановой. Во-первых, хочу сказать, что все-таки вначале сказать, что работа все-таки состоялась. Я просто определила вот такие направления, схемы себе сделала. Первое, что она хорошо рассмотрела сегодняшнюю очень интересную тему в лингвистике, это проблема текста и дискурса. Дискурсивное пространство вот на новом материале, в новом ракурсе. Это первое. Во-вторых, я хочу сказать, что у нее новый подход к юридическому дискурсу. Это лингвосемантический и когнитивный, который дал вот такой хороший результат, я думаю, что для этой работы. В-третьих, я вижу, есть весомый вклад в юрист-лингвистику. Это новое лингвистическое направление сейчас. У нас в Евразийском университете вышел 4-томное учебное пособие, которое так и называется «Юрист-лингвистика». Я думаю, и ваш труд это тоже внесет сейчас, потому что очень много юридических специальностей почти в каждом вузе Казахстана изучается. Это в-третьих. Так, в-четвертых, я что увидела? Так, в-четвертых, я вижу, что очень хорошая, достойная, солидная методологическая база исследования, которая позволила ей сделать вот эти внушительные выводы. Это в-пятых. В-пятых, хочу сказать, что конечно же, эту работу отличает междисциплинарный подход, о котором вы хорошо пишете, фактического материала, который вы взяли. В-шестых, я хочу сказать, что в этой работе хорошо рассмотрены очень сложные проблемы в лингвистической науке, не только вот в английской, но и в русской, казахской. Это проблемы полисемии. Тем более в юридическом тексте полисемии, ну, я думаю, что многозначность, термин должен быть однозначным, это однозначно, конечно. Вот вам тавтология. Как известно, проблема многозначности полисемии очень актуальна и в лексикографии, в теоретической и практической лексикографии. те, кто работает с лексикографией, вот Институт языкознания, который издает наши ведущие словарные произведения, конечно же, они тоже встречают, у них тоже есть наработки полисемии, и они знают, что это очень сложная проблема для лексикографов. Так, в-седьмых, я уже сказала. Так, восьмое. Конечно же, в одной работе невозможно все охватить, но вы хотели все сказать в этой работе. Но я думаю, что вы, конечно же, вот такой параграф или там глава это у вас, да, где вы рассматриваете когнитивный анализ полисемии в казахском юридическом языке. Я думаю, что это будет подспорье. Я думаю, в вашей работе вы только лишь показали новые возможности вашего исследования и вижу перспективы. Я думаю, казаховеды возьмут на вооружение, надеюсь, и они рассмотрят эту проблему более глубже. Вы просто дали схематически. Вообще можно было и не включать это, конечно. У вас английский язык. Ну, раз вам захотелось это показать, что это возможно, что это нужно, что это необходимо. Ну, и в итоге хочу сказать, конечно же, любая диссертационная работа, она обязательно должна иметь и теоретическую, и практическую направленность. Это у вас есть. Я сказала про методологию, я сказала про перспективную вашу работу. И я думаю, что у вас очень солидная апробация вашего материала. Многие прочитали, будут знать. И вижу вклад в юридическую лингвистику. Спасибо.
Thank you very much. Спасибо, Жанылдық Нагизбаевна. Келесі сөз, next speech for the Анар Муратқызы Фазылжанова. Перевод нужен? Перевод нужен? Выступление. Ну, коротко, да? Хорошо. Қысқаша.
Thank you very much, and I would like to tell about the review about Rahia Toksanbayeva's dissertation. First of all, I would like to talk about the discourse, and I think it was very meaningful. I have several about 8 approaches, and let me tell about them. Number 2 approach, this is kind of new approach, cognitive and comparative analysis was playing a meaning role in the dissertation. The approach number 3, it is kind of the new introduction of lexical directions. It was done very carefully, and it was very done positively. The number 4, positively, the approach number 4, it is efficiently solid methodology base, and according to the interdisciplinary approaches was done very carefully. And of course, I would like to express my gratitude about respectable methodological foundation to this research, which allowed to make remarkable conclusion. Then the approach number 5, I would like to say that, of course, this work was distinguished by the interdisciplinary approach, which you described very well as by the factual material that you need. The approach number 6, I want to note that this work examines a very complex problem for general science, and not only in English, but also in Russian and Kazakh, the problem of polysemy. Moreover, in the legal theory of polysemy, I believe that the multiple meanings are problematic. It must be ambiguous, and this is unequivocal, as well as knowing the problem of polysemy is a highly relevant in lexicography, but the theoretical and practical. So those who work in lexicography at the institute responsible for publishing our leading dictionaries, of course, and also encounter the issues, they also have their own approaches in the polysemy, and they know that is very important, a complex problem for the practitioners. And in conclusion, number 8 approach, I would like to identify that it is impossible to explain everything with one work, of course. We would like to tell about everything in this study, but I think that such a framework where you examine the cognitive analysis of polysemy in the Kazakh legal language, which indeed be useful. I think that in your work, you have demonstrated new opportunities for your research, and I see real prospects. I believe Kazakh linguists will adopt this approach, and I hope that they will consider this problem in greater depth. So you have provided schematic outlines, it could even have been omitted. Of course, you used English, but since you wanted to show that this is possible, it is very important and necessary, and you have done your work very great. Thank you very much.
Thank you. Next speech for Anar Muratқызы.
Рахмет Гүлмира Баянжановна. Құрметті әріптестер, Токсанбаева Рахия Қуантханованың диссертациясын алдында берген болатын. Мен ағылшын тіліндегі мәтінді аудармашының көмегімен біраз қарадым. Сондағы түйгенім ол жұмыс өзінің алға қойған мақсатына жеткен. Өйткені диссертацияның тақырыбы ағылшын тілінің материалы негізінде деп тұр. Сондықтан ағылшын тілінің материалын диссертант өте жақсы пайдаланып, өзі көздеген заң дискурсындағы лингво-семантикалық және когнитивтік сипаттамаларды мына көп мағыналылықпен екі түрлі мағына беретін, екі-үшті мән беретін контексттерді жақсы қарастырған. Бұл жерде мен алдымда сөйлеген Жаңылдық апайдың пікіріне қосыламын. Шынында да диссертант өзі ізденген саласы бойынша өзінің диссертациясында көрсеткенде юрис-лингвистикаға үлес қосқан диссертациялық жұмыс арқылы. Енді мен өзім қазақ тіл білімінің маманы болғандықтан кез келген диссертациялық жұмысқа өзімнің призмамнан қараймын. Және біз Қазақстан кеңістігінде болғандықтан тілтанушылар, өзіңіз сияқты диссертант Рахия Қуантханқызы, сіз сияқты мамандар болашақта біздің қазақ тіл білімінің кеңістігін дамытуға аса үлкен үлес қосу керек. Сондықтан сіздің диссертацияңыздың перспективалары туралы айтқым келеді. Қазіргі кезде заң дискурсында тілдің мәселесімен айналысып жүрген лингвист мамандар жоқ, жасыратыны жоқ. Ол юрис-лингвистикамен айналысқан мамандардың барының өзі саусақпен санарлық, және олардың өзі қазақ тіл білімінің, қазақ тілінің мамандары емес. Ал бір өкініштісі, сонымен айналысуға ниет білдіріп жүрген қазақ тілінің мамандары әлдеқашан дамып кеткен заң дискурсының бірізділігі, стандарттылығы жолға түскен ағылшын тілді мәтіндерді, ағылшын тілді зерттеулерді тереңінен түсіне алмайды. Сондықтан сіз сияқты мамандар бізге алтын көпір болу керек деп ойлаймын. Қазіргі кезде, бірақ енді бір ғана осыған байланысты сізге айтатын ескертпем де бар. Болашақта ескере жүріңіз әрине. Бұл ескертпе сіздің жұмысыңыздың маңыздылығын, сіздің жұмысыңыздың жетістігін ешқандай төмендетпейді. Дегенмен де сіз мында жазыпсыз, енді орысша оқып берейін: отсутствие стандартизированного юридического лексикона, опора на общеупотребительную лексику, влияние русскоязычной практики, составление законов способствует увеличению семантической неоднозначности и трудностей интерпретации в казахском юридическом дискурсе дейді. Енді бұлай кесіп айту дұрыс емес. 30 жылдан бері тәуелсіз мемлекет, біз заңнаманың негізінде жаман болсын, жақсы болсын, өзіміздің еліміздегі заңдық қатынастарды құрып келе жатырмыз. Мүлдем стандартталмаған заңдық лексикон, оның барлығы тек общеупотребительный, жалпы қолданыстағы лексикаға сүйенеді деп жазбасаңыз абзалырақ болар еді. Осындай бір азын-аулақ ескертпем бар. Әрине бұндай орын алған бар заң дискурсында. Бірақ біздің заң жүйеміздің тарихы өте тереңде. Егер сізді қызықтырса, біздің институтта қазір іс қағаздар стилінің тарихына қатысты Скопус базасында профессор Нұргелді Уәлиевпен бірге жазған мақаламыз жарық көрді. Біз қазақ іс қағаз стиль, соның ішінде енді заңнама тілінің де негізі өте тереңде қаланғанын, оның клишелерінің әлі күнге дейін сақталып заңнамада қолданылып жүргенін, біздің де заңнама дискурсымыздың тамыры терең, дәстүрі бар екенін көрсеткенбіз. Болашақта осындай зерттеулерді пайдалана отырып, сіз қазақ тіліндегі, қазақ тіл біліміндегі юрис-лингвистиканы дамытуға үлес қосады деп сенеміз. Оған біз сізге зор қолдау білдіреміз. Рахмет.
Рахмет, Анар Мұратқызы. Ағылшын тіліне аударасыз ғой?
Thank you very much. Yeah, we really appreciate your dissertation and let me tell my the review. The reason that this work is important and that the material you have presented in your dissertation demonstrates the unique of the English legal language, and the dissertation itself makes a contribution to the field of linguistics. As a specialist in the Kazakh language myself, I view your dissertation work as a significant and relevant. Moreover, in the context of Kazakhstan, linguists and our colleagues and the other specialists recognize your dissertation as an important contribution, both academically and personally. The development of the Kazakh language must, of course, receive great attention, and in this regard, your dissertation should also contribute to the future perspectives. At present, it must be said openly, there are many specialists in legal discourse in Kazakhstan. That's why the development of the Kazakh language in the field must be emphasized, and your dissertation should play a main and a key role in shaping this perspective. I would like also to add that the significant specialists actively engaged in the study of legal discourse in Kazakhstan. And this is a very important practical importance, offering a forward-looking perspective for the development of the Kazakh legal language in general. Thank you very much, and thank you for your dissertation work.
Thank you very much. What's your name?
My name is Awil Yerjan. Awil Yerjan, yeah. Awil. Қазақша Awil, yeah.
Енді Awil Murza или Ержан, sizге көп рахмет. Thank you very much for the translation. Okay. Dear members of the discussion council, if there are no dissertation, if there are no comments or openings, I propose moving to the final stage of the process. According to the established procedure, we shall now proceed to the vote on the dissertation. The floor is given to the academic secretary to explain the voting procedure.
Dear members of Dissertation Council and the official reviews, please allow me to explain the voting procedure. The Dissertation Council will conduct a secret ballot to adopt one of the following decisions. First, to confer the degree of Doctor of Philosophy or Doctor in the profile. The second, to return the dissertation for revision and to send the dissertation for defense, to reject the awarding of the PhD or doctor in the profile degree, or to reject the recommendation to the committee to award such a degree. A dissertation may be recommended for revision if the procedure proposed corrections do not alter the essence of the research and relate only to minor textual remarks. If the dissertation does not complete the clauses 4 and or 6 of the regulation, or partly fails to meet the principles listed on clause 5, it will be returned for defense. In cases of violation of academic integrity or failure to meet the principles or scientific novelty, internal consistency, and validity, the dissertation will be rejected and the degree will not be awarded. Official reviewers participate in the secret ballot, and their votes are counted equally with the votes of the members of the Dissertation Council. Please be guided by the provision of this standard regulation. During the voting process, I kindly ask everyone to turn off their microphones until the secret ballot is completed. Thank you.
Thank you, Kamara Sagingalivna. In accordance with the procedure, we must now establish a counting commission to summarize the results. A proposal has been submitted to form the commission with the following members: Dosanova Albina Maratkhanna, PhD, Associate Professor of the Al-Farabi Kazakh National University, Chair of the Commission, Junusova Janıldık Nuruzbayevna, Doctor of Philology, Professor of the Gumilov Eurasian National University, Member of the Commission, Kakimova Mayra Iringaipovna, Candidate of Philological Sciences, Associate Professor of the Manash Kuzubayev North Kazakhstan University, Member of the Commission. Do any of the Council members have objection to the composition of this Commission? No? No objections. Then the Canteen Commission and the Chair are approved by consensus. Now we will take a short break for the secret ballot. Thank you. Short break. Dear members of the Dissertation Council, we now resume to the session of the Council. The floor is given to the Chair of the Accounting Commission, Dosanova Albina Maratkhanna, to announce the results of the secret ballot. Albina Maratkhanna.
Dear members of dissertation committee, thank you, Gulmira Bayanjanovna. We must now formally approve the dissertation of the Dissertation Council. I propose putting it to vote. Okay. Based on the result of dissertation defense, the Dissertation Council adopted the decision to award Rahia Toksanbaeva Kuathanovna the degree of PhD Doctor of Philosophy in the specialty 8D02306 Foreign Philology, Western Language. Thank you for the members of the Counting Commission for your work. Now I want to say the results. Results of the vote awarding Rahia Toksanbaeva the degree of Doctor of Philosophy in the specialty Foreign Philology 8D02306. The first one, award of the degree of Doctor of Philosophy or Doctor in Profile 9. Send the dissertation for revision 0. Recommended the dissertation for redefense 0. Result, refused to award the degree of Doctor of Philosophy or Doctor in Profile 0. Chair of the Counting Commission Dosanova Albina, Commission member Junusova Janaldık, and Kakimova Mayra. Thank you very much.
Thank you. Thank you, Albina Marat. Структура? Алло. Thank you very much, Albina Maratvanna. We must now formally approve the decision of the Dissertation Council. I propose putting it to a vote. Who is against? No. Who abstains? No one. Who is in favor? Daus Piremus. Who is in favor? Okay, thank you very much. All members voted in favor. No votes against. The decision is adopted unanimously based on the results of the dissertation defense. The Dissertation Council unanimously adopts the decision to award Rahia Toksanbaeva, Rahia Kuankanovna Toksanbaeva the degree of Doctor of Philosophy, PhD, in the specialty 8D02306 Foreign Philology, Western Languages. Thank you, the members of the Counting Commission, for your work. But, dear colleagues, we have the final statement draft and classification codes of the dissertation. The next item of the procedure is the discussion of the draft and the codes. Now we are going to discuss the final statement draft. Does anyone have any comments on the final statement draft? At the hands draft, okay? See? What comments? Project. No comments. All right. All right, yes? Okay. Let us determine the classification codes of the dissertation. A classification features of a dissertation. First, the nature of the dissertation results. First punkt. 1, 1, 1, 2, 1, 3. What? 1, the 1, yes? Yeah. 2, the level of novelty of the dissertation results. 2, 1. Yana Alexandrovna?
What
2, 1,
exactly
yes? Okay.
should I? Uh-huh.
3, the value of the dissertation results. High, satisfactory, unsatisfactory. High, yes? For correspondence of the dissertation topic to the directions of scientific development and or government programs. 4, 2. Or 2? Regional state? No. The topic is included in the fundamental programs. 4, 2, 4, 1. Albina. 4, 2, or 4, 1. Okay. 5, the level of implementation use of the dissertation results having practical significance. At the international level, at the inter-industry level, industry-wide, within the organization. At the international level, yes? 5, why? 1. 6, recommendation for the expanded use of the results of the dissertation that have applied significance. 6, 1. Okay, thank you very much. Thank you very much. And are there any suggestions? If they are known, I propose we put it to a vote. Who is against? No. Who abstains? No. Who is in favor? Okay, all. There were no objections. The draft statement is unanimously approved as the basis. Thank you. The floor is given to Rahia Kuankanovna Toksanbaeva. Please.
Dear members of Dissertation Council, the chair and the reviewers, and I'm kind of guess everyone. I would like to begin by expressing my deepest gratitude for taking your time, for reading my dissertation, for giving me opportunity to present my research today, and for your careful attention to my work. Your questions, your comments, your insights, and your feedback are very valuable for me, and I will certainly help me improve my research in the future. With all my heart, I want to
Yeah, I'm a little bit. I want to thank everyone here who contributed to this process today. And thanks for the reviewers who came here and gave me their constructive feedback today. And I also want to thank my supervisors, my domestic supervisors, for supporting me and for being very patient with me, especially when I cried, I vented and complained a lot. Thank you to my foreign supervisor for hosting me in Tallinn and for giving me opportunity to teach her in her class, for trying to help me publish my articles. It was a really nice experience. Thank you very much for that. And I also want to thank Malika Muratovna, who was also patient with me throughout these years, who was like scolding sometimes, pushing me, but she was also the comfort who would say, it's going to be okay. And I also want to thank the temporary members who also attending this consult to this defense today. And there are two more people that I also want to thank. They're not here today. It's Taiva Rosenmasihanovna, because she inspired me to study legal linguistics. She was one of the reasons why I've chosen this, and I'm so happy I listened to her. And also Danila Almazbekovna, who also supported me when I in this journey. And I want to say thank you to my colleagues at KIMEP, my associate dean, Joseph Luke, who also supported me in this process, and Agiri Musabalinova, who also pushed me hard to finish this dissertation, and everyone who has been my team for the past 2 years. And special thanks to my mother and my children. Sorry. For making this journey happen. And thank you a lot for your attention,
Thank
for
you.
everything.
Thank you, Rahia Juankanovna. We wish you success. Congratulations, okay. Dear members of the Dissertation Council and guests, thank you for your work. The meeting of the Dissertation Council of the Defense of the Dissertation by Rahia Juankanovna Toksanbaeva is declared closed. Thank you all. Bye. Good day.
Thank you. Thank you, dear colleagues.
Thank you, and Rahia,
Thank
congratulations.
you.
And congratulations here.
Goodbye.
Bye.
Bye.
Have a nice day.
Yes, have a nice day too, all of you.
Запись сақтап алыңыз. Айдана, біз бітірдік, аяқтадық.